Okay, as we get started here, guys, I want to thank you all for coming this morning. And today we're going to talk about intellectual property. And I'm going to try something new where I wish I kind of still had a blackboard like back in the olden days. So I'm gonna try to simulate this as a whiteboard view here. So today we're going to talk about intellectual property, the entrepreneur's guide to intellectual property. And I want to make sure that I do have the chat window. I still do have the chat window still up. So let me make sure that you guys are there. Oh, wait a minute. That's weird. Hold on, I think it changed my view, so I think it oh, hey Aleshka. Let's see here. All right, let me do this. Hey Aleshka, I'm going to try recording.
Okay.
So I'm putting you on mute and I'm putting you on stop video. But then I want to make sure that my chat window still pops up, and that's what I'm wrestling with now. Ah, there it is. Okay, so my chat window is up, and here we go. So we're going to talk about intellectual property, the entrepreneur's guide to intellectual property. Okay, the first thing I think that's important to know is you want to think of it just like you do real property. If you think of intellectual property, otherwise known as IP, as actually existing in the universe, just like you would if you created a little statue or you created a painting and you had that in the physical space, and all the things that you can do with real property, you can do with intellectual property, which means you can create it, you can sell it, you can transfer it. And when you see this word, that's what transfer means in a more legal word. You can do anything that you can do with real property, you can do with that. So that's pretty much, those are the main ones. Create it, sell it, transfer it, buy it. That's the other one. So the types of intellectual property that they are and that we're going to cover today is, you've all heard of trademarks, and then there's copyright. Notice copyright is spelled that way because you want to think of it as a right afforded to you, a legal right. And I'm not really poking fun. Like sometimes we can think of it as like that because we often think of it as covering written works. And we're going to go over these as to what they are. And we have patent, and we have trade secret, which is a really kind of fun one to think about. So those are the 4 types of intellectual property that exist in the world. There's little subsets off of those, but again, we're not going to go too deep into that. And we're going to cover this. Let's make sure I spelled it right. And so a lot of times that's just a fancy word of, how do I get permission to use this, 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 and this? And how do I get permission to use trademark? How do I get permission to use copyright, patent? We're not going to cover patents too much because a lot of times for the base entrepreneur, there's really not that much you guys are doing in the patent world, but I'm still going to cover it just in case you do. So this is the big one, trademark. Okay. With trademarks, a lot of times we get people ask about, they want to know about their logo. They want to know about their tagline. So for example, let's do it like this. They ask about what they know as a trade name. And they want to know about their own name, which can be a trademark. So when we're talking about trademark, these are the 4 basic types of things that you can trademark. And we're going to talk about why you want to have a trademark, and we're going to talk about the misconceptions of having a trademark. And again, you want to think of this as your trademark is just like real property. So once you create it and put a design behind it, you can protect it as if it were like a painting or a statue. So most people, when they think of trademark, they think of this. They think of the logo. And they think of it because they've created a design, they've created a drawing, they've got a picture, and they feel like it's really unique to their field, and so they want to go ahead and get it protected. And that's what they think of as a trademark. And they think of these other things as something different. They're not. So when you create a tagline, that equals a trademark. That's where you go get that thing protected. When you have what sometimes is called trade name, that is also a trademark. And you can have your own name exist as a trademark. So trademark is the catch-all term, and then you'll sometimes hear logos just referred to as mark, taglines, Alpha Construction. I'm using that as a trade name. You'll hear that term, and then you'll hear somebody's own name. So one thing I want to pause before we dive even more into this trade name area here can get really confusing. So trademarks exist both at a state level and at a federal level. We're going to be talking about them at a federal level. A lot of times when you go to the Secretary of State of your state and you create your business name, they call it a trade name, or sometimes called a DBA, doing business as. So in that sense, the trade name means the name you pick to get registered with the Secretary of State. The reason why I say that is a lot of people come to me and they're like, I thought I had my trade name protected. I registered it with the Secretary of State of my state. And you did to some degree. You got it protected, arguably from other people using it within your state, but that's not a federal trademark, nor is it even a state trademark. A lot of states actually have state trademarks as well. And so what I'm basically saying is you can go to the Secretary of State, have your trade name registered as Alpha Construction, and then you can go ahead and get a trademark for the same very name. So they're 2 different concepts when you're dealing with your state. So you just want to know that when you register with your state, you haven't done this. You haven't done your federal trademark protection. To do that, you have to file a trademark application with this entity called the United States Patent and Trademark Office, also known as the USPTO. That's where all intellectual property that gets registered gets registered. So, what does a trademark do? So, what mostly people think it does is they think that it protects them for the world. They've created, you know what? Is everybody with me? Does anybody have any questions at this point in time? I also want to make sure the chat feature is working for all of you in case you do have questions. So if you can send me a little message that says I'm good or keep going or got it, that'd be great. Then I know that I haven't lost you. All right, thanks, Ben. Ben says none yet. All right, what does a trademark do? A trademark protects you. You get it registered, you filed it, you have this beautiful logo, you have your gold seal, United States Patent and Trademark Office, and nobody can use your mark, right? And the answer to that is no, wrong. There's a lot of confusion around this area. What a trademark does when you get it registered with the United States Patent and Trademark Office is, first of all, there are a whole bunch of classes that exist for that trademark. So there can be multiple registered trademarks with exactly the same name as yours. There's a second tier that enables you to know if you're protected or not. Tier 1 is the mark registered? That affords some level of protection. The second tier is if you were the first in right to use it. We say first in time, first in right. You were first in time and you were first in right in the whole nation. We're not going to talk about international stuff now. In the whole entire country, if you've created it first, then you have what we lawyers call common law rights to your trademark, even before it gets registered. If you're then the first at the registry, first in time, then you have registered your mark, and with the two, you've created it first and used it first, and you registered it first. With those two things, you can now stop other people from using your mark, because you can say, I have it registered and I created it first. So a lot of times in this world, in this country, since people, when I was going to say the world, the words and thoughts are sort of the same, you'll often find that you go ahead and you get a trademark and it's issued. You have your little gold seal and everything. You paid your money, you filed it, you have it issued. But somewhere out there in the country, could be Idaho, a company is using your exact name. They actually have the legal right to say, hey, I see you have a federal trademark. We want one too, and we were first, so we're going to try to cancel your mark. And that can happen. Or they can send you a cease and desist letter and say, hey, we were first. You can't use it. And your argument is, well, we registered it, you didn't. And so that's where trademark litigation comes into play. So what's important for entrepreneurs to know is it's not a granted right once you get it. Okay? The theory is that it is if you have both. So what's one to do? Like, well, why bother having a trademark? Well, here's what I recommend you do. First of all, you want to think like these people. Apple, famous, and here's another one. I mean, we could use tons and tons of examples. But the reason why Apple is such a strong trademark is because the mark is disassociated with what they do. Nobody would have associated computer technology with an apple. And so because of that, they were actually able to be first in right. You know, they created it first. They created that concept in the very beginning. So that means when they went to the trademark office says, yeah, we have lots of apples in the fruit and farm class. I don't know what that class is. Remember I said there's a bunch of classes that you can file at the trademark office. Yeah, we don't have anything under computers for Apple. We have everything that's tech and cyber and, you know, whatever would be computers back then. Computer words, general terms. So Apple, boom, perfect. Trademark office issues it. And in the real world, nobody's using the term Apple with that marketplace of computers, manufacturing computers. Same thing. Uber's a word, you know, Apple's a word. Uber's a word, but it's never been associated with taxis before. And so it's a very unique, disassociated mark. And here's one that's a little bit associated. We have micro and then we have software. They combined the two terms and they created their own term. So they just took two terms, blended them together. You know, I imagine what they meant with micro was microcomputers, because before that, computers would take up whole rooms. And so I don't actually know the origin of Microsoft, but that's an example of blending two words together. And it's slightly associated. You have the software in there. So that's a really brilliant mark, because to people in that industry, they're going to understand what that means. And so what I recommend entrepreneurs do is step one is you want to find a mark for your business that's disassociated from what you do as much as possible. What that does is allow you to be the first in the country. And then when you file, you're also first and you get it through. Now, what I often run into is this is where you want to be working with a branding agent and a marketing agent. Okay. So the challenge in the real world, forget trademark for a second. The challenge with it is in the beginning, when you were Apple Computers, okay, they had to do a lot of branding work, a lot of marketing work to get the public to associate that. So there's a lot of upfront education, marketing, and teaching to get people to associate computers with Apple. So the good news is you're new and you're fresh and you're creative. The bad news is people don't know what you're talking about. And so it can be difficult. I'm going to use a colleague of mine. His business is called Integrated Fitness. And, lo and behold, that's a common terms to use when running a fitness studio. He's a personal trainer and fitness studio owner and bodybuilder. And so that's a difficult mark to go ahead and get, distinguished, because you actually do a search and you'll find 3, 4, 5, 6, 8, maybe even 50 Facebook pages out there that talk about that. And so the good news is that in the beginning, when we create our businesses, we go, oh, we have to create something that people will know what we do in our trade name. And the good news is, yep, they'll know it pretty soon. But the bad news was when you go to try to trademark it or distinguish yourself, you'll find out it's really common, especially in today's day and age with Facebook. I mean, there could just be a Facebook page called out there. It could just be a hobby group. And here you are, you have confusion over people are Google searching you in your area, and that Facebook page is popping up, but it's not you, Integrated Fitness. It's the other person who's not associated with you at all. So I really recommend to people that are starting out, either starting their business or starting a new product line, starting a new, coaching product, and you want to give it a name, then you want to work and really work hard on the branding and marketing piece and try to be as disassociated as you can. Or because you might not want to, you might like, well, I want to spend all that money, time, and education teaching people stuff where it's not going to easily associate. So, or you can say, well, I'm going to pick a name that people will recognize, and I guess I'll just understand that if I go to try to bring it to a national scope, I may run into a lot more confusion. So what else is a poor entrepreneur to do? Step 1, disassociated mark. Step 2, you want to actually do a nationwide search. Okay. Now there are search companies that you can hire. Forget the pricing. I haven't looked at the pricing in a long, long time. Back when I was practicing, I knew more. And they will do searches. They'll search Facebooks. They'll search Secretary of State registries. They'll search other states. They'll search URLs. And so you've come up with this name. You can hire the company, and they'll tell you what exists out there in your space. A lot of times people in the beginning, they're like, oh, I don't care if they're out in California. I'm not going to, be confused with them. Let's say you're opening up a cafe, and you're going to call it, Great Beans Cafe. And there's a Great Beans Cafe out in California. You're like, well, I'm not going to be opening any branches in California anytime soon. The problem is Facebook and Google. And so all of a sudden, if that's a super popular cafe and you become super popular, the Facebook feeds can get confusing, and a lot of people do marketing through Facebook. So you can hire a search firm. You can try to do your own search. You can jump on GoDaddy. You can check URLs. You'll find a lot of times that the URL link is dead. Nobody, somebody owns it, but they haven't done anything with it. And then what do? You don't know. But you can check websites. You can check Facebook. You can see if your name or your tagline is out there and potentially being used. If it isn't, that's great. If you find that, right, and here's what I do recommend. If you do find that you do a URL search, you do a website search, and you do, maybe you dive into, you'd have to go to each state registry if you did it yourself. You dive into 10 most popular states or something, and you find it doesn't exist, you might really want to consider trademarking, because then you will have the rights to exclude everybody else from that. And that's it. So it's create a disassociated mark if that's what you so choose. Do a nationwide search. Jump into the federal registry. You can go to the USPTO, jump in there, search trademarks, see if there's any trademark applications pending. And then if not, you've got good grounds to go ahead and file your mark. And we're not going to go into the details of how to file a trademark or even the nuances of that. There are some nuances there. That's potentially a topic for another day. All right. Before I go on, does anybody have any questions they want to type out into the chat? And what we're going to talk about next is copyright. And then we're going to briefly cover trade secret and then patents, and then we're good for Q&A. All right. If there are no questions, then copyright. Copyright also is a lot of confusion for my fellow business and entrepreneurs out there, okay? So here's the cool thing about copyright. One of the great things about living in America. When you create a work of art, it is automatically copyrightable, okay? So you take a picture, it's automatically copyrighted. You create a font, it's copyrighted. You carve out a statue, it's copyrighted. You make a painting, copyrighted. You write a poem, copyrighted. Automatically. You don't have to file it anywhere. You own that property because you created it. Now, in today's day and age, again, with the internet, this is causing a lot of problems. It causes market confusion. It causes overlap. It causes cease and desist letters to go out. Here's what I mean. You have your blog. You have your Facebook. You want to post a little saying and talk to your tribe, talk to your community. You do a Google search. You find tons of pics. You find a pic of a mountain. Doesn't look like anybody's tried to copyright it. No names on it. It's not behind a proprietary wall of any kind. It doesn't say the little C. It doesn't say copyright. And you think, okay, great, it's on the internet. I can use it. Well, you actually can't. You can't, and it's a violation of copyright law. Whether you can or you can't is a whole other issue. So that is owned by somebody else. And what I'm seeing out there, a little bit more than I'd like to see, is all of a sudden one of my business clients gets the cease and desist letter either from Getty Images. They've pulled an image from Getty Images. They don't mean to. Okay, all of the times people come to me, they didn't know they were doing it. They thought they were searching something and doing the right thing, and they thought this was freeware, free use. And we're going to go over how to determine that. So they pull the picture. It's on their blog. They get the cease and desist letter from Getty Images. A cease and desist letter says, hey, we own that image. You're using it. You need to pay us a fine for violating copyright law, and you need to cease and desist from using this mark. You need to take down your post. You need to go back and delete it wherever it's been, and it can be, quite an issue. And so a lot of confusion exists around that, so let's cover that now. So confusion number one is, I thought I could use it as long as nobody's name was on it. They didn't express that they intended a copyright usage, and they didn't have the little C. Nope, those aren't the triggers. The triggers are if someone else created it and you didn't, it's somebody else's. Think of it like real property, okay? That'd be like if you found a jug. This is what we used to talk about in law school, the clay jug. You find a clay jug filled with water. It's just sitting there in the field. Nobody's around it, and you take it and use it. You know it's not yours, so you've taken someone else's property. That's how you want to think of copyright. The other confusion people think with copyright is, I understand I didn't take the picture, Rafe. Yeah, I get that. I just used it, but I'm not making any money. I'm a nonprofit, or I just have subscribers. I make no money from that blog article whatsoever. So they think, if I don't make any money, that makes it okay. It's not a violation of copyright law. Nope, that's wrong too. Money is not the trigger whether somebody's copyright you're using. Is it somebody else's art? If it is, you're violating copyright law. Where money comes in is, if you're a low little fish in the sea, you might not get the attention of Disney to say, hey, you took a picture of Ariel the mermaid and you stuck it on your blog. Sure, if we're just a little fish in the sea, Walt Disney may just not bother with us. And they only bother with us when we suddenly, get interviewed by CNN or something like that, or Fox News or something. So, or a blog or a YouTube video starts to get, 1,000 million hits. So that's where the money thing comes in. But technically speaking, it has nothing to do with money. The other confusion is the educational use. So you'll see sometimes people think, well, no, I'm more educating here. Like I'm teaching people about trademarks and stuff. Again, I'm not making any money type of thing. And so I thought educational use was a exception from the copyright laws. The answer to that is no. That's another huge misconception. What you're remembering is that the creator of content back in the day, remember you used to get those workbooks and it would say permission to photocopy and use for educational purposes only. What that's doing is the copyright owner, rather than you calling them each time and going, hey, can I use that page in the workbook? Can I photocopy that as a teacher? I was an old high school teacher back in the day. I didn't have to call the owner, the publishing company, and go, can I use that? they're granting the use of it right on the bottom of the page, and they're saying, may photocopy for educational use only. Meaning, you're a school teacher, you want to give it to your students, we're automatically giving you the right to do that. But Granger, don't be trying to take this and put it in a blog and make money as a tutor on the side. That we're not going to allow. But I think the public has interpreted that little byline to me, oh, as long as I'm using it for educational purposes, even if it doesn't say it on the bottom, I'm okay. No, you still have to get permission from the copyright owner. What's the other confusion that I see? The other confusion I see is there's people that that kind of worry, like, oh, well, if I use a picture, I know it's not mine, but if I use it and you've just taught me all of that, is there like the copyright police? And they're going to kind of like go ding dong and be like, you violated copyright law, and then there's all these penalties. And the answer is no, but with a little yes that we'll talk about later. There's no copyright police. There's no trademark police. The people that you're going to get the letters from is not the government. You're going to get the letters from other people that have the mark. If I was that teacher and I was wrongfully using that workbook, I'm going to get a letter from their lawyers that says, hey, we've learned you're using our intellectual property like this. You shouldn't be. Please cease and desist. And that's where it's going to come from. So we'll talk about the little exception, because you may be sitting there going, well, I'm pretty sure, Rafe, when I see a movie, there's that little FBI warning there, and it looks pretty scary, and it says this is the rights of the movie company and the artists, don't use this. So that's the police. Yep, you're right. We'll save that for later. It's a little side area. So again, with copyright, once you create it, you own it. There is no free educational use. Okay, there is no free use if you don't make money with it. That's not what does it. There's no free use if you are small. Okay, those are not the triggers. It can be registered at the USPTO. Okay, if you create it and if you own it, Aleshka takes a photo and she publishes it, she can put her name in the little copyright single. Doesn't have to pay the USPTO anything. You can automatically show that you have a copyright over it. Not so with trademark. You'll see sometimes TM, meaning trademark, or R, which is the registered circle. Those are the two marks, and you'll sometimes see TM pending. You can do that, but only if you have a mark that's that you're putting through the USPTO. So for copyright, you own it. You can put it right on there. Well, Rafe, I thought you said you own it. Why would anybody register? Aha. The reason why a novelist or a screenwriter or somebody who's truly marketing their copyrighted material and they are looking to protect it, the reason why they register it is it becomes proof to the world that I believe this is mine. So the reason for that is you will be amazed at how many times in the world at the same time I'm thinking of a movie idea, it's being co-created by actual screenwriters over there in Hollywood, and it's because we're all kind of connected in society. And so honestly, truthfully, I never looked at another use a script. I had no idea. I created this whole movie idea that's being co-created simultaneously. So there is a method for me to go ahead and file that, because there's a notice in public publication procedure, same for trademark, that puts it out to the world and says, hey, Rafe's claiming that he's created this. If anybody has a belief that it's not his, it's somebody else's, here's your time to step up and be heard, so to speak. So that's why there is a forum to register copyright. And I'm not going to get into the nuances, be like, well, if anything's co-created, Rafe, haven't you created, this legal guide for entrepreneurs? Didn't you just say you own that? Yep, I own that under copyright automatically. Okay. And if I want to get a trademark under that, I can. You can have both. And so their answer as to, well, what gets trademarked and what gets copyrighted, again, is beyond the scope of this webinar, but this group call. But in basics, what it is that everything that's created is copyright. The copyright's the weakest of all the protections. The next strongest is trademark. only some things can be trademarked, okay? So those things are logos, taglines, names, basically words, and words that are used for business and in two-state commerce, between two-state commerce. So trademark arguably is a subset of copyright, but we lawyers don't think of it that way. But that's the distinguishment. There's just a more additional level of protection, if you would, above and beyond copyright. So what's a poor entrepreneur? What's a poor to do? If I'm creating something and I want to create a blog, which is mine, and I want to take a picture, oh my gosh, you're like, what do I do? Well, what you want to do is you want to be aware that if the picture's not yours, it's copyrighted by somebody else. Could you do it? Sure. Is there a copyright police? No. Are you going to draw the attention of somebody out there who believes they own it? You could. You can get a cease and desist letter. Well, okay, I'll just put it down. Okay, if it's one blog article, fine. But what if you had a huge marketing campaign behind that article and those images? Well, now you're into a problem. So what you do is you work with your graphics designers to create your own logos. And you make sure that they're not going out there. A true graphic artist will create it from scratch. You want to make sure that your graphic artist isn't pulling something that's not considered free for use or is content by somebody else. You want to make sure the fonts that you use, you have a license to use. Like right now, I'm using a Microsoft font. I have the license to use it because I've paid Microsoft for the use. And so I'm using it. I'm using it to teach you guys about this. I'm not claiming I created this font, and I'm not selling the font itself, but I have a license. License means use to use it, or the ability to use it. So this is the other thing. This is going to make photographers really happy out there. Pictures. You know what I'm recommending? Hire your local photographer. Pay them some money to create what people in the film industry call B-roll. And then you can have pictures of streams and flowers and mountains, or even better, you leaning against a lamppost or, whatever. So just hire a photographer and pay them for 200 pictures that you can use over and over and over. Some photographers might even have their own gallery. Sure. Can you jump on the interwebs and find a company that sells and gives you a license to use photos? You absolutely can. And so you can use those companies as well. You pay a monthly fee and you have to read the fine script, okay? Some are, you can use any of the photos they have as long as you're a member. And some are, once you download your 50 pictures, you own them forever. Some you don't. You have to read the fine print or check with a lawyer about it if you're concerned. And by the way, I would be. I can't tell you, I must have had probably, 20 different clients come to me with just simple blog articles that reach all of 250 people, and they're getting cease and desist letters that they have to pay lawyers to defend against. So it can become the notice of people. Speaking of notice, as you get more popular, as you spend more time in years in your business, as you make more money, you start to get the attention of a lot of different entities because you're starting to push your mark out there. By the way, the person that sends you a cease and desist letter is not a nasty person necessarily. Okay, it's not that they're being a jerk. Walt Disney is not being a jerk to you in the eyes of the law to take down your blog post with Little Mermaid. Why? Because when you own a trademark and you own a copyright, it's up to the owner to police it. If they don't police it, they actually risk it being abandoned, meaning it can be argued against that they shouldn't have the mark anymore. And so if Ariel isn't policed by Walt Disney and it exists on 1,000 people's blog sites all over the place, and somebody wanted to use Ariel for something and Walt Disney said, no, we don't want you to use that because you're pretty big and you're going to make a lot of money. That person could literally argue and be like, oh, I thought you abandoned it. You didn't care because these 1,000 people have been using Ariel for 10 years and you didn't even care. And so that's why that cease and desist letter comes out, is they're actually doing what the law requires them to do, which is police their mark. Okay, in the last 5 minutes, and then I'm going to open up the cameras and the mics to Q&A. In the last 5 minutes, patents, and then we'll talk trade secret. So the patent is the same idea of a trademark and a copyright. This is where most people think of them as you've created an invention. You've created a thing, and you believe that thing is protectable. Why should it be protectable? Again, super high level answer. The theory behind patent is, let's say I create a new vacuum cleaner and it is able to vacuum without any kind of vacuum bags and without any kind of chamber. I don't know, let's just say. Well, what'll happen is me, little Rafe creator who created that in my garage, and if I spend all the money to get it manufactured and make a prototype, and I spend $300,000, and then to make this really awesome new invention that cleans floors never before, well, what's going to happen? The big companies are going to go, that's a brilliant idea, and they're just going to steal my idea because it's not patented, and they're going to just put their own little tweaks on it so it's not quite identical. And then due to the, Walmart takes it, due to their massive distribution, their massive war chest, their massive amounts of money, they will squash me right out of competition because I'm not as big as them. That's what patent is for. Patent is to encourage inventions to be created and not borrowed by larger companies that can go in half the time and due to their massive resources. That's why patents expire after a certain amount of time. It's considered after that, it goes into what we call the public domain. Again, I won't go into the nuances of that. So if you think you've created a physical thing and you want to get it patented and protected, especially if you're going to distribute it, that's where patent is useful. Not going to get into things like business methods patents or surgical patents. You can patent certain methods and things that aren't tangible, but again, that's subject for another time. Let's talk trade secret real quick. Okay. Trade secret is intellectual property. Cool thing about trade secret is you don't register it anywhere because the United States Patent and Trademark Office, copyright, trademark, and patents, public domain. So you don't have to show your technical specs. Actually, I think you do with patent, as a matter of fact. So yeah, you're putting into the public domain, you're putting into what exactly your thing does and what your thing says and what you're claiming ownership over. If you have a trade secret like Kentucky Fried Chicken's recipe, that doesn't get registered anywhere. And yet it's still intellectual property. So those franchise owners, first of all, they don't know the recipe of how to make the Kentucky Fried Chicken. The way you protect, or Coca-Cola recipe is another one. The way you protect your trade secrets are only certain people know, and you just have to trust them that they won't divulge that secret. And then, of course, there's agreements you can put into place that say if you ever did divulge our trade secret, that's where your covenants not to compete and your confidentiality contracts come in. We can sue you for breach of contract. Of course, your trade secret's out, but you can sue for breach of contract. But the actual trade secret itself is kept your intellectual property by not sharing your knowledge and your know-how with people outside of you that you don't trust, so they can't steal your processes. So that's what trade secret is for. Real quick, I get asked this all the time. How or when to hire a lawyer on this? So step one would be if you're creating a new business or you have a new idea for your business, it would be you want to work with a branding person and a marketing person to try to keep a disassociated mark and a unique mark as much as possible, and then how to market it. Step two would be, nope, I don't want to go that route. Well, you want to see what your competition is like. You can talk to a lawyer, a trademark lawyer, or a lawyer in business and say, hey, I want to try to figure out what my competition looks like. Maybe you hire a trademark search. Maybe you get one of those done. Maybe you just do your own. But you can work with a lawyer at that very early stage. You can often consult with a lawyer, and they might charge you an hour of their time to consult with you. Why would they charge an hour? I thought lawyers will talk for free. Sometimes they will, but in this field, these lawyers in this field, somebody's always got a killer invention. Somebody always has a killer idea for a trademark. So they literally would run out of hours in their day if they consulted for free. So you might have to pay for the consult to then learn, hey, your thing's not patentable, but it's better than wasting money on getting a patent when you thought it was. Same thing for patents. A lot of times I recommend you want to talk to a patent lawyer. Sure, you might have thought of a great invention, but you want to talk to a patent lawyer when you think, you know what, I actually want to do it, make it, and produce it. then you want to talk to a patent lawyer. Patents are expensive. You know, they can run $10,000, $20,000 to hundreds of thousands of dollars. So depends on what it is and how complicated it is. And for that, you would want to hire patent attorneys that have separate licenses. They are attorneys and they are licensed to practice patent law. And not, I don't have that license, and not everybody has that license. So you just search out a patent attorney. They're very usually high hourly rates, even just to get that kind of consult. But it could be worth it in your type of thing. If you had some trade secrets, again, you might want to consult with a lawyer as to how to protect that, or how to, you know, if you start to expand and you want to try to franchise or something like that. So that's my little primer on trademarks. Let me go to the top and let me unlock the video and stop recording. Hold on here. So thanks for listening, and wrong button.